Good evening, everybody. We're going to do a little bit of setup here, and then we'll start in just a moment. Lizette, take your time, but once you have the translation set up, we'll start.
I think it's all on your end because you're the host.
Hmm.
You're on the bottom of all those options. There's a little globe. Or I can see if I can take that.
Got it.
Yeah, okay.
So you need me to hit that. Okay. Ricardo, I think you're ready. Tell me if that looks live on your end. Okay, looks good. All right, well, thank you everybody for coming tonight. My name is John Alden, and I'm the director of ILARO, the Independent Office of Law Enforcement Review and Outreach here in Sonoma County. And we are putting together this town hall tonight in order to answer questions to the best that we can about our investigation into the shooting death of David Pelaez-Chavez about 3 years ago in 2022. And so we're going to cover a variety of topics tonight. We'll take breaks periodically so people can post questions or we can clarify points that people want some more information about. We might not be able to answer every question, so there are some state law limits about the information we can share. We've already released a written report that we worked with a variety of other people in the county on to make sure it was only releasing that information that we legally can release and that we legally must release. In the field in which we're working here, police oversight, sheriff oversight, generally speaking, California law creates a set of pieces of information that we cannot give to the public and another set that we must give to the public. And it really leaves us with no discretion about which is which. There's no gray area here. So either some of the material we collected is public or is not public. And I stress that at the beginning because sometimes people have frustration or concern about what is public or what isn't public. And so I want you to know that that's all set by state law. And so there's no discretion anyone's exercising here about what is and is not public. And maybe in some other meeting, we could have a longer conversation about how those rules work. I'll be doing a presentation tonight with some PowerPoint slides. I'll switch to those in a minute. You may have already seen our report online, and if you want, you can certainly follow along with that. We have tonight some translation in Spanish. Maybe I'll let Lizette speak to that briefly. So if there are people who are Spanish speakers on the line, they'll have more information about how to get the interpretation if they don't know already.
Buenas tardes y bienvenidos a la presentación sobre el reporte, la investigación del caso de David Pelaez-Chavez. Si necesita interpretación, hay un globo hacia abajo de su pantalla que dice interpretación. Ahí le puede hacer clic y ahí Ricardo, usted podrá escuchar a Ricardo traducir la presentación de esta noche. Gracias.
Okay. Thank you. And Ricardo and Lizette, if over the course of the evening we don't have anyone who needs translation by, say, half an hour in, if you could let me know that, that would help because I will be speaking slowly and taking breaks to facilitate the translation. And if it turns out we don't need translation, then I might present just a tiny bit faster. For those of you who are English speakers and not Spanish speakers, we've been trying at ILARO to provide Spanish language translation whenever possible. And one of the things we have learned is that most of our presentations, when spoken in Spanish, take about 30 or 40% more time to actually speak than they do in English. So in order to facilitate translation, we've been trying to take breaks and slow down in our presentations. So if it sounds like there's some odd pauses along the way, that's why. Tonight you'll be hearing from me. And then as you saw, we also have Lizette Camacho here, our outreach manager. Also here for this part of the presentation is Emma Dill, who was the investigator who worked on this case. And Lizette, I think we still need to promote Emma to panelist, if we can.
I think you can only because you're the host.
Ah, that's me again. Okay, thank you for telling me that. All right, I think we've promoted Emma. There we go. And I'll do a little bit of presentation and then maybe I'll give Emma a chance to introduce herself when we have a moment. And she may be able to better answer some of the more detailed questions that some of the folks might ask. So we've also gotten a few questions online, either at previous meetings that we've done or through email or phone calls or conversation, and we've tried to work as many of those as we can in the presentation. We're aiming to have this done in about an hour and a half, which hopefully leaves plenty of time for questions. We could go longer if we need to, but we will be screening the questions just for efficiency's sake. So Lizette and Emma and I are all going to be screening the questions as they come in and try to combine some if we get questions that are close on topic. Okay. So please do take advantage of the question or chat function. There's a Q&A box you should see at the bottom of your screen. It'll help you do that. So with that in mind, let me share some slides. Okay. So just to check, make sure I've got this right, Lizette, we should be seeing the investigative impediment slide. Does that look right?
Yes.
Excellent. Thank you for helping me with that. So one of the first questions that we get at ILARO is, why did this take so long? And I would agree with the general sentiment that we would like our independent investigations to move faster than this one did. That said, there are several reasons why cases like these are complicated and do take time. They're rarely done in months. They're usually done in over a year. And in this case, we had the disadvantage, if you will, of this being the first real independent investigation that ILRO ever did, with new procedures, policies, practices that we had to work out in order to make this investigation move forward. So in the future, we would expect our other investigations would be somewhat faster than this one because we worked out some of those procedures, worked out the kinks, if you will. So one of those challenges is that there are both criminal and civil cases that run at the same time as an independent investigation like this one into a deputy-involved shooting. As you are probably already aware, the criminal case is initially investigated by a different law enforcement agency than the sheriff's office. In this case, it was the Santa Rosa Police Department. And then that investigative work is reviewed by a prosecutor. In this case, it was the Sonoma County District Attorney's Office. And the result of that examination of evidence was that the district attorney decided that there was not a prosecutable crime committed by the deputies in this case. That's an assessment made with just the information available in the criminal investigation. Sometimes more and different material is gathered in follow-up civil or administrative investigations like ours at ILARO. And it also presents a very high bar. The district attorney is not looking to see if any policies were violated, but rather whether the deputies actually committed a crime. And if so, can that be proven beyond a reasonable doubt with the very limited evidence that would be available in a criminal case? That's an extremely high bar. And so it's very rare that we see officers or deputies prosecuted in criminal cases like these. And as you probably already know, the district attorney opined that there was not a prosecutable crime here. So that case was helpful to our investigation in that it gathered a lot of facts that we used. But our process and our conclusions are always going to be quite different than the criminal case, because we're taking a look at whether policy was violated, not whether the law was violated. And so in that regard, we're really asking different questions. Plus, we can gather other and different evidence than could be gathered in the criminal case. I'll talk about that some more in this presentation. Um, but we still wanted to make sure we saw what had happened in the criminal case. Here in Sonoma County, at the time that I came on to ILRO in the fall of 2022, we also had an understanding through a set of letters of agreement reached with some of the bargaining units or labor associations that represent some of the folks that work at the sheriff's office.
John,
And yeah,
I'm sorry to interrupt. We've gotten a few comments that people are having trouble hearing you, either not speaking loud enough or maybe your microphone is too far away.
this
Sorry
is
to
as loud
interrupt.
as it gets. But this is Emma, by the way. Do you want to take a moment to introduce yourself since you're here?
Sure. Hi, I'm Emma. I am an auditor at ILRO and I performed the investigation and audit in this case.
Thank you, Emma. Well, I'm sorry, folks, that that's not louder. I'll try to talk louder, but this is as loud as the setup gets. So, as we were working on those letters of agreement, we realized that the original version, which had been completed before I got here to ILRO, had a rule that ILRO wouldn't start their work until not only the criminal investigation was done, but also the sheriff's office had completed their own separate investigation into the matter. So the first thing we had to do was go back to the letters of agreement process and talk to those unions about that arrangement and rearrange it so that we could start earlier. So that was our first delay. We've now gotten that done so we can start earlier. Our second was that there was a pending civil case, and we decided in our case that it was useful to us to see what the depositions in that civil case revealed, and that took some time as well. And so these are both ordinary and normal steps in a case like this that just take time. We also had the challenge of some unavailable witnesses. So as we'll discuss in a little bit, at least one person we wanted to interview ended up leaving the sheriff's office, so we couldn't interview them. And that person and another one were both not available for a period of time when we were trying to do this investigation, and that slowed us down. That tends to happen in these kinds of cases. It's not unusual, but that was unfortunate. Another issue we had was how the sheriff's office produced evidence to us. So the Santa Rosa Police Department's criminal investigative file was given to the sheriff's office, and the sheriff's office gave it to us. That process took approximately 6 months, and we think that could be faster in the future. We'd normally expect that to be more like 6 days. And so we've been working with the sheriff's office on speeding up that production process, and we think that's going to be a lot faster next time. Probably the most important one, which we'll discuss in this presentation too, is that at the end of the day, when we tried to interview the key deputies involved in this case, the sheriff declined to give them what are called Liebarger advisements, or orders to talk, even though they had a Fifth Amendment right. We'll talk about this some more in our next slide, but that caused some delay as well and also made us unable to, at the end of the day, answer some of the questions that we wanted to ask. And then the final issue, which is not anyone's fault, but it sometimes happens in these cases, is that the main deputy involved here, the shooting deputy, Deputy Dietrich, ended up leaving the Sonoma County Sheriff's Office, so we were not able to get information from him. That does happen in these kinds of cases. For better or for worse, that's not unusual, but that also means we don't have information from him. So those were some of the reasons why this didn't move faster. And I think this might be an appropriate time to see if we have some questions about those topics before we move on to explaining what a Liebarger advisement is and talking about the 6 main issues that we investigated in this case. And Emma and Lizette, could I ask you the favor of taking a look to see if we have some questions you think we might want to pitch here? And while you're doing that, I'll just double check to make sure I haven't missed something about turning up my volume.
Yeah, so we've received one question so far, which I think leads into the next place you were going to go, John, which is how much was the investigation hampered by not having cooperation from either the police or the sheriff's department in terms of allowing certain individuals to be interviewed?
Well, I suppose I would say first that it's really not up to the police department to make people available to us. So when any other agency is doing the criminal investigation I described at the beginning in a case like this, that is quite separate from the administrative investigation that we would do at ILRO. Would not, as a general rule, be wise to try to combine the two. There are many ways in which those two inquiries are designed to stay separate. I'll talk about that a little bit more with the Leibarger advisement on the next slide. That said, I think this next slide probably answers the question about how the sheriff's office does and doesn't make people available. So a Leibarger advisement. This was the most significant impediment we had to gathering the evidence we wanted to gather in this case. And in our written report, we go through many of the questions we would have liked to have asked, but couldn't because we couldn't get through this step. So a Leibarger advisement comes from the right that all public employees have to not incriminate themselves when they're at work. So just like you or I have a right to claim the fifth and not talk when we're confronted by an investigator who thinks we might have committed a crime or is checking to see if we committed a crime, public employees have that same Fifth Amendment right at work. So teachers, firefighters, janitors, accountants, doctors, anyone who has a job in the public sphere has this same Fifth Amendment right at work, just like any of the rest of us do when we're out in public and we're confronted by a police officer. And it's important for us to honor and respect that right in the investigative process. So the way we do that in California and in most states is that the courts have said, look, it would put an employee in an impossible place to be stuck between their employer telling them they must answer questions and their Fifth Amendment right. So what we'll do, and the US Supreme Court agrees that this is an appropriate procedure, is have the employer issue an order to the employee saying, okay, I understand you have claimed your Fifth Amendment right to silence. I'm going to order you to answer these questions anyways. And as a result of that, you will be immune or protected from those questions ever being asked, ever being used against you in a criminal prosecution of you, right? So that way the employee still has to tell their employer what happened and what they know. So the employer can figure out whether they want to keep the employee, whether some policy needs to be changed, whether there's some other employee that maybe is in trouble and the like, without the employee losing their Fifth Amendment rights. But the important thing that we have to note here is that only the employer can do that. And in sheriff's offices, that is the sheriff, not anybody else, not human resources, not the county board of supervisors, not the civil service commission, not ILRO for sure, only the sheriff. So we had asked the sheriff to issue that order in this case to the deputies that came to us when we were trying to interview them, and he declined. We haven't received a reason back that we found credible. We did get, for the first time, some answers in writing just about 2 hours ago, which we're still digesting. But our first impression of those is it seems to be that the sheriff has pointed out that if he were to order people to talk, to give them this Leibarger advisement, there would have to be some conversations with the unions for the deputy sheriffs before that happened in a process called meet and confer. And I think the short answer to that is yes, there might have to be a meet and confer process, but that can only be it can only be started by the sheriff himself by declaring his intention to make that order, and he's indicated he won't. So we cannot get to meet and confer. No one else in the county can start that process without the sheriff saying he's going to start issuing those orders, those Leibarger advisements. Some have asked why this issue wasn't resolved in the original letters of agreement, and that's because at that time we had a different sheriff Sheriff Essick, who also would not make this Liebarger order. So there was no way to meet and confer over it in 2021 and 2022, because then Sheriff Essick would not. And that just stops the process for everybody else in the county. So if what we're hearing right now is that the sheriff's office would like to go to meet and confer, then we'd certainly invite the sheriff to explain that he will start making Liebarger advisements, and we'd be happy to help with the meet and confer process in whatever way is legally appropriate. So that's how we ended up getting stalled out on the interviews themselves. We don't know any other agency that does not issue Liebarger advisements. We have seen the sheriff's office issue Liebarger advisements when they are interviewing their own deputies. And so we know that they do it for their own internal interviews. They just won't do it for ILARO interviews. Some have also asked, well, why wouldn't you at ILARO just sit in on the interviews that the sheriff's office did of these deputies? And the answer there is that the sheriff's office did not interview these deputies. So there is no opportunity to interview or sit in on an interview that the sheriff's office did, because there just wasn't one. So at the end of the day, these deputies were not interviewed by the sheriff's office, and they were not interviewed by ILARO. And so the questions we asked, as you see in our report, just weren't answered. This might be one more point at which we could take a break and see if there are some questions. And if Lizette or Emma, you see some in the queue, I'd be happy to answer them.
I do. Lizette, I see that you have one, but if you don't mind, I have two follow-up questions on this topic. The first question is, what is the resistance from the sheriff's office to actually, I believe they're asking to actually making a Liebarger order so that ILARO can ask questions. And then the second question is, if everyone left, there would be no investigation. So what protects an employee who's involved in an incident but who leaves from providing information? Can't ILARO subpoena them and require their participation?
Yeah, okay, I'll start with the second question first. As a general rule, our investigations at ILARO are investigations by the County of Sonoma. And as a result, that's ultimately by the employing agency, right? Employers like us can only force people to come in and talk if they're still employees. So as a general rule, we wouldn't expect that we'd be able to force an interview of anyone who was a former employee of Sonoma County. But perhaps more importantly in this case, even if we had issued a subpoena to someone who was a former employee and they actually showed up, they would still have that Fifth Amendment right that I mentioned earlier and could invoke that Fifth Amendment right, in which case we wouldn't be able to get a statement from them, because not only would they be able to invoke their Fifth Amendment right, but the Liebarger advisement I described earlier would not be available. Liebarger only works for current employees, and it only works when the employer says to the employee, I'll discipline you, even maybe fire you if you don't talk. That's the key trigger in the Liebarger advisement. So the Liebarger advisements are not available for any former employees. And as for, what the resistance is, I think I'd respectfully defer to the sheriff. I mean, he has provided the explanation I just provided to you about the meet and confer process. And I would just respectfully offer that I think that has the order of operations backwards. If Sheriff Ingram decided he wanted to give Liebarger advisements, then we could move to meet and confer. ILARO can't get to meet and confer, nor can anyone else in the county without the sheriff saying he's willing to do that, and he hasn't. So it's still not clear to us what the resistance is there. But we're open to having more conversation and hopeful that maybe this written response we just got today gives us an opportunity to keep the conversation going and see if there might be some other way to resolve that impasse. And Lizette, I think you had a question.
Yeah, there's two questions. The first one is, what evidence was there regarding Mr. Pelaez-Chavez having any drugs in his system? And the second question is whether the sheriffs provided any translation for Mr. Pelaez.
Those are great questions, and we are going to answer those in a couple of the slides we have coming up. So if folks don't mind, we'll get to that in just a moment. So we'd like to talk a little bit about 6 things that we considered in this case. So this is an outline of the 6 things we'll be talking about in the following slides. The first is de-escalation. What was done to try to calm or slow down the situation? 2, the shooting itself. Was that consistent with county or sheriff's office policy or not? 3, the use of a taser in this case. 4, the quality of the supervision that was provided to the 2 deputies who were following David Pelaez-Chavez, especially supervision during the pursuit. 5, the sequestering of the deputies, meaning were they kept apart from each other after the shooting so that investigators could get statements from each of them without them inadvertently contaminating each other's memory by talking about the incident. And 6, the critical incident video that came out to the public after the shooting occurred. And with each of these, we'll talk a little bit about them and give people opportunity to ask questions. So as for de-escalation, one of the things that went well or was consistent with policy and training in this case was that there was a lot of work at the beginning of the case or the beginning of the incident around de-escalation. So to back up here a little bit, the 2 deputies who initially were pursuing David Pelaez-Chavez got a series of calls about some very strange behavior in a rural neighborhood. And when they arrived, they were able to figure out that Mr. Pelaez-Chavez seemed to have taken a golf cart style of vehicle and driven it out into a remote spot and then had walked away from there. So to their credit, they started talking right at the beginning about how they could initially approach Mr. Pelaez-Chavez because they had heard some of his behavior might have been a little erratic, and thinking about how they could resolve the situation peacefully. So we can see conversations that they had on their body, recorded by their body-worn camera, and a lot of creativity used at the beginning. This was a strong positive. And the conversations that these 2 deputies had with criminal investigators and in their civil depositions reinforce this point. So at points where the situation wasn't, say, urgent or dangerous, they gave Mr. Pelaez-Chavez some space. They took their time to wait for resources like summoning a helicopter to help them with the pursuit. Deputy Dietrich, very early in the case, waited for Deputy Powers to arrive and back him up. And so that ended up being a positive. There were times when they stopped and just watched rather than running after Mr. Pelaez-Chavez. And we also see a number of incidents where they try to, or moments in the incident where they try to engage him in conversation. There wasn't just a straight up script or one size fits all approach. They tried different approaches along the way. They offered Mr. Pelaez-Chavez water on a few occasions. They tried to talk to him about his family. There were at least attempts to communicate with him and create rapport. And they did try to use what information they could to identify who Mr. Pelaez-Chavez was. Now, at the end of the day, we didn't see de-escalation in the final moments as much as we would have liked. But for the first over an hour, the de-escalation efforts are pretty substantial. And we think there's some praise that's due there to the sheriff's office for training deputies on de-escalation and for these 2 deputies in using those tools effectively in the first hour or so of the incident. Another positive, and this goes hand in glove with de-escalation, was that there were communications with Mr. Pelaez-Chavez that were not threatening, that were encouraging. Now, we do note that those communications were in very limited Spanish. These 2 deputies were not native Spanish speakers, nor were they certified to be translators. They had a few phrases that they knew in Spanish. The body-worn camera footage we have suggests that they probably did not understand or hear one or the other. some of the things that Mr. Pelaez-Chavez was saying back to them in Spanish. And that was one of the things we would have liked to have asked more questions about, but there were still at least attempts to say, as I mentioned before, offer water, engage in conversation. Also, the two deputies asked for a supervisor to be involved. That was Sergeant Burke. Sergeant Burke responded to the scene and was en route, and so could at least have been in communication by radio and had some opportunity to know what was going on with these two deputies. We would have liked to have asked Sergeant Burke more questions about what communication actually happened there and what decision-making Sergeant Burke used. But at least we had a supervisor involved at an early stage. And another was that the deputies discussed the use of a taser, which we think was a thoughtful approach, after the incident had already gone on for a long while, and Mr. Pelaez-Chavez seemed to be at least tossing some rocks or trying to toss something in the direction of the deputies. They thought a taser might be a useful way to resolve the situation. And given that a taser has some range and can incapacitate a person without killing them, that seemed like a very thoughtful approach. And they used their department training to set up an approach with the taser that was consistent with what they were taught to do by their agency. So that was actually a positive. What we don't know about de-escalation is why some of the other sheriff's office resources that might have been available weren't used. And we don't know if this is because they turned out not to be as available as they seemed to us from the evidence we had, or if there is some practical reason why the deputies ruled out these other resources. For example, there didn't seem to be any other effort to get Spanish interpreters or translators involved. We don't know why. We don't know if there was a practical reason why. Maybe that service wasn't going to be available that day for some reason. It would have been useful to assess that so we could give advice to the sheriff's office or some support to them about how language access could be made more available. The deputies summoned a helicopter, which we thought was wise and an effective tool to have at their disposal. But once it reached the scene, they didn't seem to use it any further, and we don't know why. No one's asked them that, and we don't seem to have any evidence about that. We'd certainly like to understand that better. There was certainly reason to believe that Mr. Pelaez-Chavez's behavior was erratic and odd, which would suggest a mental health issue or that he was under the influence of a narcotic. The deputies wouldn't have had a direct way to know for sure whether either of those two things were true during the incident, but certainly the behavior they saw suggested it, and it's not clear that they sought any other mental health resources. Maybe those are not available. Maybe they don't have training about that. Maybe there was a practical reason why those weren't available. Maybe they just didn't think of it. We don't know the answer to that question. No one's asked them, either us nor the sheriff's office, and we'd certainly like to know that. I think that could be useful in looking at ways responses to future situations could be improved. We also don't know if anyone thought about just stopping the foot pursuit, especially once the helicopter arrived. Could the helicopter have been used to just follow Mr. Pelaez-Chavez? At that point, he was in the wilderness. There wasn't anyone else nearby. Both of the deputies were clearly tired and thirsty. The terrain was very difficult. Radio reception was sketchy. Once the helicopter arrived, couldn't they have just used the helicopter to follow him until he eventually emerged from the woods or stopped somewhere? We don't know the answer to that question. I would have enjoyed finding that out from Sergeant Burke and from Deputy Powers. I think that would be useful in helping other deputies in future situations, but we don't know the answer to that now. We also don't know what exactly Deputy Dietrich heard near the end. We can tell that Mr. Pelaez-Chavez is saying help in English. He had also been saying that in Spanish. But we don't see a response from Deputy Dietrich, and we don't see that anyone else has asked him about this. So we don't know if he didn't hear that or if he didn't respond for a specific reason. There's also a moment near the end, just before Deputy Dietrich fires shots from his firearm, in which Deputy Dietrich has explained in his interview in the criminal case and in his deposition in the civil case that he thought Mr. Pelaez-Chavez was going to hit him with a rock. We're not exactly sure why that is. There's a fair bit of information, which we'll get into in a little bit, that makes us not clear about why he would think that, and we would love to have asked him more questions about that. More specifically, right near the end, we're wondering what exactly were the movements that Deputy Dietrich saw Mr. Pelaez make before Deputy Dietrich fired his weapon. The ones we see in the video suggest he was only reaching towards the ground when the weapon was fired, as opposed to actually winding up with something to throw. Also, we're not sure why Deputy Dietrich got closer to Mr. Pelaez-Chavez in the final moments. He had a firearm. At best, we think that Mr. Pelaez-Chavez had some tools in one hand and was perhaps reaching for a rock with the other. We also don't know why Deputy Dietrich didn't wait a few more seconds for Deputy Powers to use his taser the time the shots were fired. Deputy Powers had his taser out and was ready to use it. And their agreement had been to try to use the taser first, so it wasn't clear to us why not wait for that. Now, we have some images that walk through these details a little bit more, but perhaps this is a place to pause and see if we have some questions. Yeah, go ahead, Emma.
I have one question that I think is just a clarification from when we were talking about the interviews about whether the letter that the sheriff sent to Ialero today, the written response that they've provided on the Liebarger issue, can be made public, that I thought you might want to clarify.
Yes, that's going to be part of our annual report presentation next month at the Board of Supervisors. So I do anticipate that's going to be a public document. And Lizette, did you have questions over on your end?
No.
Okay. Give me just a moment. Okay. Now, I do want to mention before we get into the next couple slides that these slides are accompanied by pictures of the final moments of this incident. And they include some description and discussion about what we see going on in these images. For some, these may be graphic enough that they might be disturbing. These have all been released to the public previously, so these are not new, but some of you might not have seen them, and I want to give that context before I switch to these next few slides. So we picked this image to include in this presentation because from our analysis, this appears to be the final frame or image in the body-worn camera from Deputy Dietrich, the shooting officer, when the first gunshot from Deputy Dietrich can be heard in the video. So this is the moment at which the gun went off. So you can see what was visible in that moment, which is Mr. Pelaez-Chavez bending over with one hand at or near the ground. Now the image quality here is as good as it's going to get. So I have to point out that there is a fair bit of blurriness and the image isn't perfect, and that's one of the limitations of body-worn camera, but at least we have an image. We think this image is important because it does not show an actual throwing of a rock. It shows a reaching at best for a rock, perhaps even a hand on a rock. I think it's also important to note that anytime someone fires a firearm, there is some amount of time that passes between the decision to shoot and the gun actually going off and the bullet firing. So this image comes from the moment the gun actually discharged, which means that Deputy Dietrich must have made the decision to pull the trigger on the firearm at some point very shortly before this image. Now, there is a lot of debate in the law enforcement community and in the scientific community about what exactly that period of time is. I think it's safe to say that there's some general agreement that it could be anywhere from half a second to a second and a half. And anywhere in that range, one would have seen images in the body-worn camera of Mr. Pelaez-Chavez starting to bend over or starting to reach toward the ground. It's impossible to know at exactly what moment Deputy Dietrich formed that intention and then pulled the trigger, but we know it was some point within a fairly short period of time before this image. This is important because in law enforcement analyses, sometimes the thing that is happening in the second or so immediately before the shot is discharged looks more threatening than what is happening in the actual split second that the gun goes off. And I do think it's important to include that information in communications with the public so they can see that the deputy or officer was almost certainly reacting to something that happened roughly a second, plus or minus half a second, before the trigger actually was pulled and the shot went off. In this case, what we see in that range of time is at most Mr. Pelaez-Chavez starting to bend over and reach towards the ground. So we would have liked to have had more conversation with Deputy Dietrich about what he thought was happening in that, say, second or so before Mr. Pelaez-Chavez actually got to the position you see in this picture. Now, I'm going to switch to another slide here that also has some images from body-worn camera, so the same advisement applies here. These are snapshots from Deputy Power's body-worn camera and from Deputy Dietrich's body-worn camera. And we took these because it shows different moments in the course of this incident at which Mr. Pelaez-Chavez picked up rocks. It did happen more than once. So the reaching for the rock in the final moments of this incident was not the first time that Mr. Pelaez-Chavez was reaching for a rock. These are examples of him holding rocks at other points in the encounter. And we know that he, at least at some point, threw rocks. But we also don't know that those rocks ever got close to either of the deputies. It is a little hard to know if these are the same rock. It's probably more than one rock, and that would have been something we would have liked to have asked about too. We can't always determine all facts from just the body-worn camera. An interview with the deputies involved is essential in understanding the images we're seeing. So this leaves a variety of unanswered questions. I'm going to move to one more slide and then see if we have some questions. This is another slide that shows the relative position of Mr. Pelaez-Chavez on the left and Deputy Dietrich on the right in the final moments of this incident. We would like to have asked Deputy Dietrich why he was this close. Obviously, his firearm has a much greater range than you see here, but it's also true that firearms like his are not very accurate at long distances. So why this distance was optimal isn't clear to us, and we would have liked to have asked that. I should note too that body-worn cameras, especially at wider angles like this, can sometimes distort perspective. So it's hard to see depth in these images, and that's a bit of detail we don't have without interviewing some of the deputies involved. I would like to go to one more slide after this that has some images that are also pretty graphic, but I'd like to take a moment and see what questions we have. Lizette, Emma, do you have any questions in the queue that we should take a look at right now?
We have a request to talk a little bit more about what Mr. Pelaez-Chavez was doing that might have created fear in Deputy Dietrich, which I think ties into the next slide some.
Yeah, let's talk about that in the next slide. I think that's a good point. So I think it's interesting and important to think about all the things that the deputies knew when we get to this final moment in which Deputy Dietrich fires his firearm. And Emma, I might need your help here to make sure I'm hitting all the relevant details, because there are, frankly, a lot. And there are some that aren't relevant. So one thing that's important to know is these deputies at this point knew nothing about Mr. Pelaez-Chavez's personal life, his history, his employment, or any criminal history he might have had. So Mr. Pelaez-Chavez was a blank slate to them at this point, at least from the information that we have. We know that the deputies knew that Mr. Pelaez-Chavez had already at least appeared to have tried to break into a house, had acted in a threatening way towards at least one person who lived in the neighborhood, who seems to have said something along the lines of wanting to die or kill me, and was behaving in a way that didn't make any logical sense as he was walking away up the hill away from the deputies. It was a hot day, really tough, difficult environment. He didn't seem to have any clear destination. There wasn't any logical place of refuge that they were aware of he could get to. He seemed to just be wandering away in the woods. And when he did talk to the deputies, they were not always able to understand him. Now, some of that was because he was speaking in Spanish, and we're anticipating that had we interviewed the deputies, they probably would have said they wouldn't have understood what he said in Spanish, but we don't know that. It would be useful for us to understand whether they understood what he was saying back in Spanish, because to the extent we can hear that on body-worn camera, many of the things he's saying describe him being afraid or worried or irrational or just incoherent. And so we think if someone were a Spanish speaker or could understand Spanish, that probably would have cemented the deputy's belief that something was very wrong with Mr. Pelaez-Chavez at that point. We do know that he picked up and tossed some rocks at a few points during this, and so there's some reason to believe he had the intention or the thought that he might be throwing them at the deputies. One of the deputies described one of the throws as like throwing a baseball, so some energy behind it. And he was carrying at least two objects that could be used as weapons in close quarters, some kind of tools. Now, of course, those tools were found after the shooting had happened and Mr. Pelaez-Chavez died. But at the time of the incident, they were having a hard time identifying whether those were, a hammer, some kind of like digging implement, maybe a small pick of some kind. So they could make out well enough that these were, tools that were hard and substantial enough that they could be used to cause substantial injury. So there was certainly very good reason to not get too close to Mr. Pelaez-Chavez and to believe that he had objects that could be used as weapons. So absolutely there was reason to keep a distance and to be worried about him, both because of those objects and because of the erratic behavior and because of the erratic behavior described by some of the people at the scene who had met Mr. Pelaez-Chavez before the deputies got there. And I'm wondering, Emma, if I'm missing some important details you'd like to add there.
So I would just want to note that when you're looking at something like a shooting or another type of force, all of the facts that the deputy has matter. And so it's sort of impossible to do the laundry list of everything that the deputies either say was in their mind or that you might reasonably believe they had knowledge of. But I think you hit most of the points, John. I think it's important too to know, in addition to sort of the crimes that you talked about, there are some other property crimes, stealing a utility vehicle, trespass, some of those things. And so when you think about the crimes that he committed, you think about them sort of as a whole when you try to determine whether they're particularly violent or particularly serious. But in this case, Deputy Dietrich really focused on Mr. Pelaez-Chavez's actions in the very last moment, which is what we're going to get to in this slide. And specifically his belief that Mr. Pelaez-Chavez was reaching down to pick up a large rock to get back up and throw it with the intention of hitting him, which he believed would either cause his death or unconsciousness, break a bone, any number of serious injuries. And so it's sort of, there's a lot of background information that he had, but when it came down to it in the statements that he gave in the criminal investigation and in the civil case, that was really his focus.
I think those are great points, Emma. Thank you for hitting those. The analysis of whether a deputy is acting within policy in the final moments right before they fire a firearm is very complicated. And Emma makes a really good point that all the information the deputy has up until that point is important. And it's also the case that none of us are allowed to, or the law and policy don't permit us to, second guess whether the deputy's information later turned out to be right or wrong. So, for example, in this interaction, the deputies had the belief that it was possible that Mr. Pelaez-Chavez might be under the influence of methamphetamine. That was reasonable given the very erratic and strange behavior they saw. And so they were entitled to be concerned that he might be under the influence of methamphetamine. Whether it turned out later on that he was or wasn't isn't relevant to that moment as they're trying to assess. There is no way for a police officer or a deputy sheriff to know with certainty what narcotics a person might be on. They can only make a best assessment from behavior, and they're entitled to do that for their own safety and for that the others around them. Now that also, cuts both ways in that they can understand that this is someone who's going to probably make poor decisions, and maybe they can use that to their advantage by letting the situation continue as long as possible. Here's someone who's more likely to become exhausted and collapse eventually than the deputies or anyone that might back them up would be. But on the other hand, it's also good reason to be concerned that Mr. Pelaez-Chavez could engage in threatening behavior, because people on methamphetamine are known to do that. So in this, final moment, one of the things we're assessing from a policy perspective is not just that final second of pulling the trigger, but what happened leading up to this. As I mentioned earlier, the criminal and the civil investigations ask different questions. And this is one way in which the question we're asking here in our administrative investigation is fundamentally different from those other two investigations. We do want to know what the tactics were that led up to this moment. One of them was that Deputy Powers had his taser deployed, and we think that was smart and consistent with policy and training. That said, we don't know why Deputy Dietrich fired his firearm before Deputy Powers fired his taser. We can make educated guesses, but we don't know the answer to that question. So some have asked in the Q&A, well, why wasn't the taser used? Well, it was ready, it was deployed, there was a plan by the two deputies to use it. We don't know at the end of the day why that wasn't used, and we'd like to know the answer to that question. We do know that Deputy Dietrich got closer to Mr. Pelaez-Chavez in the final seconds, that you see these snapshots here from left to right as they progressed of Mr. Pelaez-Chavez standing upright and then reaching one arm down and leaning down as if to pick something up, which suggests, yeah, he might have been picking up a rock. He had done that before. And we know that at this point, Deputy Dietrich is much closer than he had been before, but we don't know why he's much closer here than he had been before. We would like to know the answer to that question because at this point, Deputy Dietrich is now close enough that potentially an object could be thrown at him. Maybe It's possible that Mr. Pelaez-Chavez could have thrown a rock at this point, but he also hasn't picked one up yet. So we have some insight here into what Deputy Dietrich was able to see, and I think probably the fairest interpretation here was a reasonable person might have anticipated that Mr. Pelaez-Chavez was about to pick up a rock, but we also think a reasonable person would have already known that he had picked up rocks before and would have created more distance and or waited for the taser to fire, because throwing a rock is pretty difficult to do, especially at that distance. So we'd love to have assessed those questions some more, and we weren't able to do that in this case, but this is one of the core questions that at this point we don't expect is ever going to be answered, and I think that's unfortunate. Emma, you worked really hard on this part of the analysis, and I want to make sure we have a chance for you to provide whatever else you think I might have missed there.
Yeah, so I want to clarify that the taser was fired. It just wasn't fired during a time period that helped the situation, unfortunately. The taser and the gun were essentially fired simultaneously. And the deputy's explanations for that, the deputy who fired the taser, his explanation was that he was essentially trying to get within range, within position. The taser that he had fires a maximum distance of 25 feet. And so he was sort of approaching, trying to get into position, is his perspective. And then the shooting deputy, his perspective was that he felt that he didn't have any more time to wait. He had waited previously for the taser to arrive, but felt that he was out of time now.
Yeah.
Obviously, we don't, that doesn't answer all the questions, but it at least sort of sets up an understanding of what the deputies said that they understood the timeline to be. And we have one quick clarification. People want to know whether these were seasoned officers and how big the rock was. They had some experience. So Deputy Dietrich, the shooting officer, the shooting deputy, had 9 years of total law enforcement experience at the time of the incident. Deputy Powers had 4 years of total law enforcement experience. And the answer on the rock is we don't know. When the Santa Rosa Police Department did their investigation, they weren't able to identify the specific rock that might have been the one Mr. Pelaez-Chavez was reaching down to pick up. And so the best that we have is sort of a general understanding of how large the rocks were that he picked up in the 5 minutes before that. And that's what's illustrated in the previous slide where we showed different images of rocks in his hands. But body-worn camera footage isn't clear enough to see exactly what he has in his hand at the final moment. And that wasn't part of the criminal investigation, unfortunately.
Yeah, I'll add too that some folks have asked me in the past, well, why didn't a criminal investigator collect the rock? And I think the cleanest answer we have to that is, given the information we have, I think it would have been very difficult for anyone to figure out which of the many rocks there was the one that Mr. Pelaez-Chavez was reaching towards. And so, we do have some photography of the landscape there that gives us a sense of what sort of rocks were available, and that's, I think, as good as any criminal investigator could have done. So I don't fault anyone for not having that particular rock available. I don't think that was something anyone could have figured out at the scene. I also want to emphasize here that we came to the conclusion that firing the taser in that moment was appropriate. And someone might ask, well, why would it be okay to fire a taser but not a firearm? And part of the reason for that is that the taser is a lower level of force, right? It is supposed to be used when there's an immediate threat of injury or violence. And here we think arguably that could be the case. We think that it is an unanswered question why Deputy Dietrich wouldn't have waited just a little bit for the taser to see if it was effective before making the decision to shoot, and we just don't know the answer to that. I would add too, in Deputy Dietrich's defense, we do know from his history that he had once been assaulted by a suspect who got close enough to take his flashlight from him and assault Deputy Dietrich with his own flashlight. That can be a fatal blow. that must have been an immensely traumatic experience. And I think that would be a reason why a deputy might be much more concerned about people having blunt objects in their hands and maybe have a um, lower tolerance for having a suspect in close proximity with such an item in their hands. We didn't get to explore that. Um, Officers and deputies are entitled to rely on past experience to inform why they make decisions in the future, and we would have liked to have understood better if that was a factor here. Um, and that's one of the reasons why we think the questions that we could not have answers for potentially could have cut in either direction in this case. We really don't know what finding we would have made if we had actually gotten answers to our questions, and I wish that we had. So I'm sorry we don't have the ability to add that clarity for the public. I do want to hit one other thing I saw in the Q&A before we start coming to a conclusion. And that was, wasn't there a need to provide interpretation? Why wouldn't the sheriff's office have sought interpretation at this point? Would policy have required an interpreter at this point? And I think the cleanest answer we have to that question right now, the most honest answer is we don't know why the deputies didn't secure more translation services. On the one hand, we know the sheriff's office has a few different translation services available, whether that's another deputy or a translation over a phone, but we know that those are limited. And this particular incident happened in a very remote location. These deputies may have concluded, based on past experience, that those services weren't practical to get to the scene, or that they didn't have enough time. We don't know if any effort was made to secure those resources. We don't see any evidence of that, say, in the materials we already have, like radio logs, but that doesn't mean it didn't happen. So we would like to have known more about that. So we really can't answer those questions yet about why translation wasn't provided. There may have been good reason for that. There may not have been. And that would be a great lesson to learn so that situations like this could be handled differently in the future. Lizette or Emma, do you see any other questions in the queue that we haven't gotten to? Before I move to the critical incident video? No?
There's none in Spanish.
Okay.
Oh, Lizette, we just received one in Spanish as you said that.
It says Mr. Pelaez-Chavez did not seem aggressive so that the officers would be feeling threatened by Mr. Pelaez. The officers had the possibility of using different use of force to protect themselves.
Yeah, that's an interesting question. So the sheriff's office is not equipped with a passive way to protect oneself from a rock or a sharp implement like the ones that Mr. Pelaez-Chavez had. They didn't have shields or armor or anything like that. So the tools that they had available would have included the taser, which would allow them to incapacitate someone from a distance. So that's another reason why we think it was wise for them to try to use the taser here. Some of their other tools, like a baton, for example, or pepper spray, require getting even closer, which would not have been wise in this situation. So really, the only tools the deputies had were the taser and the firearm. And to their credit, they separated those two tools so that one was using the taser and one was using the firearm, which is consistent with, generally speaking, best practices and training. We talked earlier about why the deputies felt threatened by Mr. Pelaez-Chavez. One of the things that we're a little unclear about is why they chose to close distance and confront him as close up as they did at the point that they did. Clearly, in order to confront him and physically stop him, they would have needed to get close enough to use the taser, which explains why Deputy Powers was as close as he was in the final moments. That said, why was that moment in the pursuit the moment at which to close quarters, as they say, and get close enough to use the taser? Why not just keep following Mr. Pelaez-Chavez? So in some ways, there's a concern here that the decision to get close to Mr. Pelaez-Chavez at that point created more danger than was necessary, and that letting him stay at a greater distance, which was something the deputies had a great deal of control over, wouldn't have been safer. And that's one of the tools, distance, that we don't fully understand why it wasn't used more at this point in the case, if that makes sense. So to answer that question that you passed on, Lizette, there was one tool, distance, which was not used in the final moments, and we don't know why. Let me cover a couple other points. The final issue we talked about was the critical incident video. And we wondered, why was it that the critical incident video that came out just a few days after these events described Mr. Pelaez-Chavez as throwing a rock? Because we don't see that in the body-worn camera footage. We see him reaching for a rock at the time the shooting happened. And we think that gave the public a false impression that there was some active rock throwing right at the end of this incident. There wasn't. It might have come to that eventually, but it didn't. And that critical incident video not only gave the public information that was inaccurate, but we're concerned that it might have misled some of the deputies involved. For example, we know that these deputies watched that critical incident video in preparation for their civil depositions, which happened a long time after the shooting, and that some of the statements that they made in that deposition suggests that they remember a rock actually being thrown or being wound up to be thrown. And that's just not consistent with the body-worn camera footage. So our concern is, did the critical incident video end up causing false memories for both of these deputies because they reviewed it so many times and it said something that wasn't true? It's known that witnesses' memories will start to change if they're told a statement over and over again, even though it's inconsistent with their memory. And so we think that's a problem. Now, to the sheriff's credit, we understand they don't use the vendor that created this critical incident video anymore. And the more recent critical incident videos we've seen have been more even-handed and more careful about describing details like that. We think that's a positive development, and we'd encourage the sheriff's office to keep moving in that direction. Similarly, one of the things that we don't know enough about is whether the sergeant, in this case, Sergeant Burke, considered just calling off the pursuit or giving direction to use the helicopter to extend the pursuit so it would have taken longer, and so more time and distance could have been created. We don't know the answers to those questions because we weren't able to interview Sergeant Burke, but we'd like to. There might be important lessons there for other people in the sheriff's office to learn about how to manage a scene like this one. And then the final thing I'll mention is that the sheriff's office did do their own investigation. They did not interview any of their own people. It was purely a review of the materials gathered in the criminal case and the civil case. So that report does not answer any of the questions that we had in this presentation either. But it did get into a fair bit of detail about what Mr. Pelaez-Chavez had been doing earlier that day and his past criminal history, as if that would justify the use of force. We think that's inappropriate because these deputies at the scene would not have had that information. And so if they didn't have that information, then it would not be appropriate to use that to assess whether their use of force was proper or not. And we think that's, to be fair, a challenge we see in many law enforcement agencies. Many do issue final reports in cases like these in which they include a lot of details, usually negative details about the person who was shot, that were not known to the shooting law enforcement officers at the time. And so we think that shouldn't be part of the analysis because legally it can't be part of the analysis. I know that's a lot of information, and we've had a number of questions. Lizette, Emma, do we have any other questions you think that we haven't answered yet?
We have one big picture question. If you can clarify that you talked about how this was the first of a new type of investigation for ILARO to conduct. Can you talk some more about why this was a new situation, how this is different from what ILARO has done in the past?
Sure. Historically, ILARO has only done audits, meaning we've double checked the investigations done by the sheriff's office. We have not had opportunity in the past to directly investigate, meaning go talk to witnesses ourselves and reach our own independent conclusions first, as opposed to just double checking the work of the sheriff's office. We got that power through Measure P, and then it was the subject of a meet and confer process, such that there is a set of letters of agreement that describe how to use some of those powers. And this particular incident was the first one subject to Measure P and the letters of agreement that allowed us to do an independent investigation. There will be others moving forward, but this is the first one where we were able to complete an investigation into a shooting in the field. So that's what's new and different about this, and there are others in the future that well, not that we hope that there are incidents like this in the future, but we certainly hope we're able to complete other independent investigations in the future. Emma, is there anything you might want to add that we haven't covered?
No, I think it's important for people to understand that these incidents are complicated, and that our intention is to approach them from a place of neutrality, to look at everything that we can get our hands on in terms of evidence, whether it's interviews, video, documents, whatever we have that might be relevant to it, and try to start from zero, looking at sheriff's office policies and looking at the facts and do our best to figure out what happened. And so I think one of the big takeaways that you mentioned earlier is that we just couldn't get our hands on some of those facts this time. And that was problematic for us doing our jobs.
Yep. I'll hit just a couple other questions I see in the queue. One person asks the status of the civil suit that was settled some months ago. And yes, the family of Mr. Pelaez-Chavez sued, and yes, that's been settled and resolved. And we use some of the information generated in that set of proceedings to inform our questions in our investigation. Some asked how many people attended tonight, and while I haven't been able to see the total number, the number of attendees at any point tonight has varied between 25 and 30 for most of the evening. So somewhere in that range. And then there was also a question if there was any audio from the supervisor. I think I'll need to pitch that question to Emma. I'm not recalling that, but Emma might.
Yeah, so we have the audio that we have from the scene is a mix of the body-worn camera footage and then the dispatch radio recordings. There's a small amount of radio traffic between the deputies and either the sergeant, who was the supervisor, or the other deputy who was partnered with the sergeant during this incident. We see some communications about the deputies' locations, what direction they're traveling. But we don't see really any communications between the deputies and the sergeant about how they're feeling, how the pursuit is going, their distance behind Mr. Pelaez-Chavez, the terrain that they're dealing with, any of those types of things that we talked about that a supervisor might be aware of and consider so that they could provide guidance.
Okay. I think those are all the questions we have. And so I want to thank folks for attending tonight. Let me end the share here so you can see me. I really appreciate people making the time and asking some really thoughtful, interesting questions. You're welcome to send us other questions by email or phone call, or next time we're at a CAC meeting, and to the extent we can, we'll try to answer them. There is not any other further work on this case. So at this point, this is the end of this investigation for us. But as I said, we'll keep you posted about our other work in the future, and we'll make sure that this town hall is available online so other people can watch it later as a recording. So thanks again for your time. Really appreciate you spending so much time chatting with us on a Monday night about this very complicated case. And again, thank you for the thoughtful questions. Have a good night.